Good morning, ladies and gentlemen, and welcome to this anticipated to be the last hearing session associated with the examination of the Tunbridge Wells Site Allocation Local Plan. My name is Ryn Smith, and I have been appointed on behalf of the Secretary of State for Communities and Local Government to examine the plan. And the Programme Officer for this examination, Lynette Duncan, is sitting to the rear of the room. As is normal with these sessions, I will introduce the Council and the parties present here after some, I hope, brief initial observations about the venue and hearing arrangements for today. My first question, in order to frame my opening remarks, is to ask whether there is anybody at all sitting in this room who has not attended a previous session of this examination or who is unfamiliar with this as a venue. No, that is extremely good news and enables me to cut away quite a lot of superfluous material. All I will say to you, ladies and gentlemen, is that I have checked. There is no fire drill programmed for today, so if the alarms go, it is the real thing, and use the procedure that you have been previously advised of to leave the room. The council staff in those circumstances will act as our marshals. If I can then move on to arrangements for this morning, the only substantive matter on the agenda for today is the finalisation of oral submissions on behalf of Cooper Estate Strategic Land. We will run with those until they are concluded. If we need to take a break at somewhere around 11:30, we will do so. However, I will judge the process as it runs, and if it appears that we would be close to concluding at that time, I will just push on. We will then end the morning session at the time it naturally ends, which will leave me with some time for preparation, and indeed others who may be attending or participating with some time for preparation for the afternoon session that will commence at 2 p.m. Now, that is not a substantive hearing session. That is very much of the nature of a business stroke wash-up. Its purpose is exclusively to ensure that principally the Council and I are of a shared mind over all the actions that have arisen from the various sessions of hearing that have been held and that are still outstanding. The dates are programmed for documents to be prepared, exchanged, etc. And it's also an opportunity for me to discuss with the Council and indeed any other interested parties who are present and have been involved in earlier hearing sessions, the reporting arrangements associated with this examination, so that those are clear to everybody who has been involved. So, as I say, no substantive business this afternoon, no submissions in relation to sites. So this morning brings substantive submissions on sites to an end. In terms of preliminary and procedural matters before we move into this morning's business, I have got only one that cannot wait until this afternoon, and that is that Cooper Estate Strategic Land have produced a written note of proposed oral submissions. Whilst that wasn't a document that I specifically asked to be produced, it is nevertheless a very useful document, and I did check with participants in yesterday's hearing whether there were any objections to it being brought in, and most critically for today's purposes, there were none from the Council. So this document is already within the examination and has been allocated its reference number 108911/6. I've read it overnight, and I'm also happy, therefore, to take it as read, but clearly there are weighty matters within it, so I'm not necessarily expecting it to be summarised in maybe quite the same way as I would with some of the earlier documents that have been with us for longer periods of time. So that was the only preliminary matter that I had. Any observations on that or any other preliminary matters that anybody wishes to raise? None. Let us then have introductions briefly for the purposes of the digital recording. If I can start with the Council and move around the table.
Good morning, sir. My name is Kelvin Hinton and I'm the Planning Policy Manager with the Borough Council.
My name is Adrian Toffs. I'm Planning Policy Team Leader with Tunbridge Wells Borough Council.
Thank you very much. CPRE.
Elizabeth Aikenhead, Tunbridge Wells District Committee of CPRE.
Now, Lady Aikenhead, in relation to your involvement this morning, a watching brief, as I would take it?
Probably.
Probably. Okay. Now, Cooper Estates.
Robin Buchanan, Director, Provision Planning Consultants on behalf of Cooper Estates.
Thank you very much.
Gregory Jones, Queen's Counsel, Francis Taylor Building, Cooper Estates.
And thank you very much. Now, if we then move on to the substance of today's agenda, matter A, a melange really of main issues 2 and 3 in relation to the argued need for land and allocations for residential institutions C2 use. And the questions set out on the agenda paper broadly frame or provide the basis for the discussion today. However, as I've already indicated, the proposed oral submissions of Cooper Estate Strategic Land, I think, very usefully articulate their position as they currently see it. And I thought it would be helpful if that can be essentially presented and then the Council will respond to it. In presenting it, there are essentially 3 broad groupings of issues arising from it that I noted last night that are all almost independent of each other and need to be kind of bedded down each of themselves. There is the ongoing issue of the resolution of a position, or at least the framing of the disagreement in relation to C2 and C3 numbers. That's a self-contained task. Then there is the scope for inclusion of appropriate policy and or allocations additionally in the plan addressing traditional C2, modern C2 and supported C3 or extra care or equivalent uses, addressing need together with current market operation and the relationship between any suggested policy amendment and the adopted core strategy. So that's the second, I believe, reasonably self-contained issue that arises. And then the third issue that arises, on which we are, in many ways, I guess, most close to being completely heard, although not entirely, is the Green Belt Review question, characterised in simple terms. And this, of course, is a question that doesn't just emerge from Cooper Estate submissions, it emerges from the submissions of a number of others, and the related emissions issue, which has already been put to me in a previous session. So there's more of a, I guess, a tidying up and final concluding dimension to that, whereas the other 2 freestanding tasks, I believe, are kind of holus bolus. They are matters that maybe need to be addressed from a more foundation stone perspective. Do those 3 issues arising from the paper that was circulated yesterday commend themselves to the main participants as framing this morning's discussions?
I think so, sir, yes. We'll see to progress it in that way. That's useful.
Are the council content that we proceed in that way?
Yes, sir.
Thank you very much. In which case, let us open the batting.
Thank you very much, sir, and thank you to the local authority. Yes, we did think it would be, simply when we were thinking about it, be useful to give prior notice rather than just simply address matters orally. And I won't obviously read out everything in the oral submissions and try and group matters. On paragraph 3, insofar as the core strategy identifies need, it is right, it does not set a specific target for C2 development or accommodation suitable for the elderly, if I can put it in that way. But it is common ground between us and the local planning authority, and I don't believe there is anyone else taking issue, that the need identified in the core strategy must be met by this allocations plan. And that was confirmed, and it's confirmed in the minute of the morning session of the 10th of November, for example. So the difference between us and the council is not that the core strategy has not identified a need. It's not that the need, such as it is, should not be met by this document within the Gladman Court parameters, but it's how best that need can be met. And
if I can just intervene briefly there, essentially how it can best be met, whether by way of an additional or additional site-specific allocations, one, and or amendments to policies or supporting text in the plan.
That's yes, and in terms of our position, we obviously say the primary position is by allocation of our site. Where there are others is a matter for you, sir. Or in the alternative, the safeguarding of our site, as in the alternative wording that we have proposed. And we'll come on to Greenbelt in a moment, but we don't accept as correct the position that appears to be advanced by the council that only non-green belt land can be safeguarded. I mean, that's right in the sense that you say you take land out of the green belt to safeguard it, but I think if it's been suggested that only non-green belt can be considered for safeguarding, that's plainly wrong, and we would urge that in the alternative to allocation that it should be safeguarded. Insofar as amendments to policies, and we'll come to in a moment, but suggestions that amendments to policies identifying conventional C3 housing as being suitable for C2, that, as we indicated at the outset, simply isn't facing up to the need to address C2 and elderly care for a number of reasons. First of all, as currently drafted, I think the two sites that the council referred to are housing allocations. So and as proposed to be amended, they are to be housing allocations, and the supporting text says that they may be suitable for C2. So the allocation is C3, and the allocation is the supporting text says they may be suitable for C2. Now, just pausing there, as we said in the outset, that simply doesn't deliver, because where you've got a situation, as you have in Tunbridge Wells, where there is, on whatever is allocated, it will not be meeting the objectively assessed housing need for conventional housing. You've got a number of scenarios. One which we say is more likely, that sites allocated for conventional housing will be used for conventional housing and not C2. Secondly, if that is wrong, as you yourself pointed out, sir, if that is wrong, what then are the consequences then of sites which are allocated for housing not delivering conventional housing, but delivering, let's say, traditional C2? Number of factors. The first is that has an impact on the council's calculations for affordable housing. Because, as I understand the council's basis to use, sir, on affordable housing, it is based off what it says can be delivered on allocated sites. Now, if at the same time it's saying, can't have it both ways, it can't say on the one hand this is going to be allocating X number of C3 housing, of which a certain percentage will deliver affordable housing, but at the same time saying, oh, we're also meeting our C2 uses on the same side, which of course will not be subject to affordable housing allocations. That's just an illustration of why if I may call it, cop-out solution of not really addressing it, of just saying conventional housing allocation may be suitable for C2 doesn't work. I mean, one of the examples is that I know you've looked at, sir, in various contexts, is the WA Turner Factory site. And that's policy AL-RTW13. And there, as currently drafted, these sites are shown, the policy says, on the proposals maps, are allocated for residential C3, providing approximately 170 dwellings in total. So throughout the plan, that is treated as a C3 allocation for all purposes. The site occupied by the Turner factory may also be considered suitable for redevelopment for a mix of market and retirement housing, which is described as C3 and C2 uses. Now, that is not an allocation of mixing. The allocation is for C3. And our understanding is that those figures are relied upon, the 170 dwellings are relied upon by the council as meeting its 5-year housing supply. They're relied upon by the council in respect of their affordable housing provision. But they're telling you, sir, at the same time that you can expect it also to deliver the C2 need. Well, it can't do both. And that's the problem with respect. That's one example. There's another example as well. But that's the example, although I know there are tweaks proposed to the policy, none of them, even if it can't perform the two tasks. That's why we say to you, sir, given the common ground that exists, that need must be specifically met for C2. We'll come on to the categories in a minute, but C2 housing. Paragraph 5 of our speaking note, we note that the council intends the local plan to contain separate targets for both C3 and C2 to be delivered, and we set them out. Now, just pausing there, we have no difficulty with the local plan proceeding in that way. But it does beg the question, why does the council think it's necessary to proceed in the local plan review on what we say is the correct approach, i.e. Specific site allocations for both C3 and C2, but is submitting to you so you don't need to worry about it for this plan, that magically somehow C2 need will be catered for. There's been no explanation for that inconsistency of approach. And the reason we say there's no explanation is because there is no good explanation, and the approach that the council proposed to take, they tell us for the local plan review, is the right one. And it's the right approach that should be taken as far as can be taken in this plan. And as I say, it's been no part of the council's case quite properly to say to you, look, sir, we can't address that need, so we're not going to try and do so. Council quite rightly have not shied away. They've said we will address that need in the allocations plan, but for the reasons we've outlined to you, so they simply don't do it. So then, just moving on the speaking note to the definition of C2 and C3 housing. Before going into this in detail, could I just highlight something you will have seen, sir? One of the key issues as it's emerged is that the council's latest work on delivery and need falls into this error. It counts as delivery, and we've got detailed issues about delivery and completion. But what it counts as delivering, apart from the YMCA building, which we don't think comes into it, but is traditional C2 uses, and if we can call modern C2 uses. And they're all counted on the one side by the council as delivery and completions, but it's only set against a need of traditional C2 uses. So it's not, it's apples and pears. And as we'll come on to see, we've requested, but it's become quite evident that the GL Hearn work has not unpacked the differential between C2 traditional institutions and C2 extra care. And with that prefix, I just turn to paragraph 10 of our note, and which identifies the point of disagreement is how the council seeks to interpret and apply some of the housing definitions contained within the SHMA and the UCO to, and we've given the document reference. The council says at paragraph 8 that specialist housing, sheltered housing and extra care, as defined by the SHMA, forms part of the overall need, C3, which is identified at table 1. And we say this appears to be based on SHMA paragraph 8.45, and we give the table reference, which is the same 1,391 specialist older persons housing need as in figure 5. The council then go on to note that the council says that registered care provision as defined by the SMAR is identified as, quote, a separate need as it principally relates to C2 use class, i.e. the use classes order, and that's set out in table 6 of the SMAR. And we give the reference, page 19. Now, the SMAR table 6 refers to accommodation for older people in the form of bed spaces for institutional population, give the reference, what we explain as traditional form of C2 residential, which is care nursing home. The SMAR goes on at 7.33 to consider, as well as the need for specialist housing for older people, that is which they've already counted in table 5, the analysis needs to consider registered care and whether there is an increased need for traditional C2 development in the light of new models of provision, including extra care, older persons other than institutional care, and that's what we've explained and we were referring to as the modern form of C2. But when you come to look at the SMARL, and we give the references, and in particular Table 63, which is it's the same 796 need figure as Table 6. The SMARL goes on to identify a specific requirement for only traditional C2 development. And in the correspondence and the digging down which we've asked the Council to do, G.L. Hearn confirmed that here the SMARL is only considering the institutional elderly population living in accommodation which does not form a defined self-contained household. So it's looking only at traditional need for traditional C2. So it doesn't identify a requirement for modern or C2 development. It doesn't do that because there isn't one. It's because it hasn't actually examined that.
Now, can I just test at this point?
Yes.
Cutting a potentially quite long story short,
yes.
Is it your submission that the G.L. Hearn work essentially is methodologically adrift on this point?
Yes. Yeah. Yes. Well, I think the answer is yes. It's either not analysed it at all, or it's somewhere buried in C3. But the short answer to your question is yes, because if it's either of those two things, it is methodologically adrift. But it's either not been addressed, or if it has been addressed, it's in C3, and it's in a way that it can't be addressed and assessed by USER, and obviously it has consequences for the way in which one approaches the C3 identified need. We're not saying it is buried in the C3. We're just saying that it's either not addressed or it's somehow buried in C3.
In a way that has eluded your discovery and explanation.
Exactly. And we think no one can dig it up. But so far no one has dug it up, if it is there. I looked to the Council, but so far we've seen nothing that's revealed a buried, hidden and quantified modern C2 use in the assessment for C3.
Okay. Now, there was another, I guess, definitional question that I wanted to explore briefly, just to make sure that we're not trying to compare apples with pears. And that relates essentially to your concern about the Council's limitation of its discussion to personal care. This is in your paragraph 20, where you're referring to paragraph 11 of the Council's document. And then moving on for your paragraphs onwards, essentially to the beginning of the next section, so up to 30.
Yes. With medical treatment. Yes, sir. This is, I think this is the debate, if I can sort of say, is the extent to which it could be said, well, if I'm Mr. Jones living in my pre-existing house and I have an arrangement with Mr. Buchanan Healthcare Services, I'd be a bit ill-advised, but anyway, he then provides for me a sort of regular checkup that someone would come and I could telephone if something happened. And the argument then being, well, that's what's the difference between that and what you are saying is a modern form of C2 use, and I think the distinction, so that whether or not you can live in a self-contained flat as part of some of the elderly care provisions that are given. Brendan Care springs to mind, is a particular organisation that does what's called full care, and the position I was just describing. And there are the number of reasons why the former comes within the extended definition and the provision of medical care, and the latter, the arrangement of me living in my house and bringing in those services, would not. All of the care facilities in the specialist housing are within the same project accommodation and are subject to various conditions who goes to live there. And although you may own that flat, no one else can come into that flat. You couldn't, when you die, as I would in my house, someone else come into it. So that area of the modern C2 use, and I think that's what we're setting out in those paragraphs there, why that comes within the definition and why it's distinguishable where you draw the line to whereas if I was just living in my own self-contained flat, buying in those provisions.
Because essentially what I just wanted to make sure that we were completely on the same page as to if that's achievable is that we're untangling the fairly complex interrelationships between planning law and provisions relevant to interpretation of use classes and the law of property and understanding what is achievable and regulable through tenures and contract. Because under each of those separate regimes there are mechanisms of essentially providing a ladder or staircase of care arrangements which proceed from C3, this is my dwelling house, and I happen to have, a specialist nurse call at my premises to deliver care targeted to my needs. But in fact, there is no planning consequence of that and no change of use in any respect, right the way up to, what you're characterising as a modern C2, which is clearly an institutional use because it is a specific facility designed for and providing a range of very particular care needs, and it is doing so in a way that doesn't envision that becoming open market housing, either for rent or for sale, but it happens to provide units of accommodation that look essentially like
absolutely
C3 housing.
Absolutely, sir. You put your finger on it, if I may say so. The fact that, as a matter of contract, let's say, and it just so happens I'm familiar with a particular company's arrangement, Brendan Care, we lived in it. There, they had a thing called total care, and it was in a which had a nursing home element in it. There was a nursing home, and then there was part of it which was total care. You happened to own, you bought your flat, but you had to fulfil certain conditions to live in the flat, and then the idea would be they had all the medical facilities on site. That as you became, if you became iller, you wouldn't have to move your room. The facilities would come to you and upgrade as you went into quite intensive care. Now, you happen to own that flat and have the equity in it, but you couldn't treat it in the same way for planning consequences as you could if I had my own house and I entered into an arrangement with, Buchanan Medical Services and had said, look, if I start getting ill, you will provide me with a nurse. Because as soon as I died, my son or daughter could move in and there would be no planning consequences. Whereas for the modern C2 use, which is trying to adapt for those people who do not want to be in the institutional nature and want to feel that they've got their own house, you may have a contractual ownership in it. The planning law still provides. You can't say, well, I own this flat, I can leave. Yes.
I mean, critically, it's the distinction between something that is capable of being seen as part of the generic housing supply,
yes,
and something that is not because of its institutional nature, both in use class terms and
yes,
the contractual relationship between the occupier receiving services and the entity providing services not just to that home but to a group of houses within a particular development.
Yes, that's right. It contributes, and this is where it becomes, it obviously contributes to if you've got an overall housing need, because obviously someone living in one of those, I'll come back to the planning practice guidance reference in a moment, if I may. It contributes to, it's capable, and this is why it's recognised as contributing to overall housing. C2 is part of the overall housing need because obviously for two reasons. One, if I'm living in a flat or an institution, that is my home, and therefore if that is being provided, I have a home there and I don't need a home elsewhere. So that's, and also, of course, one of the other complicating but contributory factors is that if you allow people the choice and you provide for the need of C2, both traditional and modern, you allow the unlocking of pre-existing C3 housing. So now that may unlock. I mean, it depends on the evidence. That may unlock more than it takes up, because, but you'd have to look at it, because I could be the widower, or the couple living in the family house, and we want to move to a Brendan Care place, so we move, and then that 4-bedroom house now is unlocked, but it's only unlocked if the C2 use is provided. That won't always be the case, because you'll have people who may not have had their own house before, or they're coming in from outside the area. So it's not. I'm not saying you can, but obviously it does have an impact on conventional housing. But it is not C3. And Mr. Buchanan referred me to it's PPG, sir, para 37 for your notes. Makes clear that it intends all forms of C2 use development for older persons should be counted against the planned period requirement, as well as 5-year land supply. Para 18. It doesn't set out a formula of how you do it, but it...
and therein, I suspect, lies the heart of...
how you do it, and on the face of it, on the face of it, you need sufficient units for the people who are going to occupy it. Now, in a sense, you're in the fortunate position here because, as I think the representative of Gleeson Homes pointed out, that whilst there's been a great deal of focus on whether the council can meet the target set by the core strategy, the core strategy sets a target, it doesn't set a limit. So and just as we know that sometimes to meet a target, in certain circumstances, you need to plan for more than the target to meet the target. So, for example, we see that with the government's approach on the 20% buffer. That's put not as a punishment, although sometimes I think it's interpreted as such on local planning authorities, but it's saying, well, look at past trends. It means you need to aim a bit high. It's a bit like shooting an arrow if the wind, or kicking a goal if the wind's blowing in the wrong direction. You need to make adjustments in predicting for the future, for the vicissitudes that you can't predict that will hold up delivery. Here we're in the fortunate position that the target is a target and not a limit. And insofar as trying to deal with the very, the need for C2 uses, which we say can only be dealt with by adopting effectively the same approach that the Council proposes to adopt in their local plan review of actually facing up to it and allocating it. In going back, sir, to your earlier question on the SMAR, we do have the advantage of the assessment work carried out, which is Mr. Buchanan will have the reference number. Yes, it's so you will have seen the Carter Wood report,
yep.
And that probably provides an illustration of why we say GL Hearn haven't approached it in the right way. The Carter Wood report does actually knuckle down to assess the need for both, if we were like, traditional C2 and modern C2, and that has been carried out in support of the current Alnest Wood planning application, which is across the road. It's not very far from our site. So that's why we've relied upon it, and that's PV1 pages 8 to 9, and it's referred to in footnote 8 of these oral submissions at page 6. And the Carter Wood report deals with those definitions, and the need case is in the Carter Wood January 2015 demand and supply analysis, which they have based on those definitions, and that is also in the is in the report that I referred you to, but obviously other pages. Oh yeah, and it's referred to. Mr. Buchanan rightly is anxious that I should give you the reference to where he has referred to that in the written submissions, which is 2.8 of our October written submissions. Provision draw attention at 2.8 to Carter Wood's surveyors and healthcare specialists January 2015 demand and supply analysis, which is currently before the Council. And the proposed development is there for 98 C2 units, comprising a 76-bed care home and 22-unit extra care on land at Pembury. And that's actually a good example of what's often the case. It's a sort of a mixture of traditional C2 and modern C2 together. And of course it comes back to, sir, the general policy endorsement by the government, just as for the non-elderly, the elderly are expected to be given a choice of housing. And of course, actually, it's one of those critical times of one's life when people have very particular views of where they want to spend the latter part of their life. And anyway, the government's policy is, as you know, sir, for a range of choice in housing. Oh, yes. Oh, and just on the October reference, there were 2 October written documents, and it's in respect of main issue 3, so just right. So that you think you probably... So I think in sort of colloquial terms, I've summarised, I hope, the essence of what I hope is set out in perhaps sort of more detailed terms at paragraphs 19 to 30 of our written submissions. But that's the essence of it. So the difference between what we say a modern C2 use is, and you've got an example there with the Catherwood development, which is a combination of the two. And the area that we would, I don't think we need to get into it, but it is an interesting point. But we say for our case we don't need to get into it. But of course the overall need, even if something was C3 on the gone on to the other side of being C3, some form of Warden, Buchanan medical services coming around the houses. That, of course, is a sort of housing need. But so our case isn't predicated on that. We're on C2 uses, and that's complicated enough.
We're indeed, and that runs. You set that out clearly in your paragraph 36. But no, the definitional stuff is important to get completely clear.
Absolutely right. Yes.
Because, not to put too fine a point on it, I suspect we are where we are because of, this is an area where, the market is changing, expectations are changing.
Yes.
And the foundation stones in terms of planning law haven't shifted with what the market is delivering, and so we're all kind of working into existing understandings of use that perhaps haven't kept pace with contemporary expectations.
I think he's right. If I may say so, it sounds an odd analogy, but I think the approach to elderly care can be compared to a certain extent to the approach towards travellers and gypsies, in the sense that, and sometimes one gets a sense of similar hostility when promoting an elderly care, which is rather odd, because we're hopefully all going to end up in that situation at some stage. And it's this. If one looks back at government policy, it's quite clear that when it was referring to homes, and also we can see with the MPPF, it's quite clearly intended to be providing homes for the elderly. And actually one can trace that back through a long history of national government policy. But very little guidance given about it, and just a line here and a line there. And I think the culture, if I may say so, the culture of local planning authorities and the culture historic has been largely to ignore C2 uses and the chronic need to provide for elderly accommodation. I don't say that in critical. It's just a fact, and it is coming to a head. And I think it's, in a sense, it's a cultural change of recognising that was, albeit buried away to a certain extent in government policy, has now become more brightly articulated and flagged up in government policy. And also because of the demographics as well. And also, as you rightly say, sir, is the fulfilling the aim of general government policy to provide a range of choice. There will be, for some people, whether by choice or necessity, institutional care is the appropriate, traditional. But for many people now, and also with technology, modern C2 is the appropriate type, and it's, I know you're aware, but so it's paragraph 50 of the MPPF, which emphasises that there should be a wide choice of high-quality homes, and widen opportunities for home ownership and create sustainable, inclusive, mixed communities. Local planning authorities should, and then it says what they should do. But I do draw attention to, and it's a slightly forensic point, but it's an important one of emphasis, that paragraph 50 is talking about a wide choice of high-quality homes, not houses. Now, and I'm not getting into the debate whether or not a C2 is a house of some sort or not, but the focus is on the choice of homes, and a choice of someone's home may be a modern or traditional C2 use, which I think the government policy recognises. So we then, so you have, I think, our proposals, which we address at 31 to 36. So you have the benefit of our representations on matter E.
Yes.
And hopefully that clarifies some possible misunderstanding as to what the council may have had as to what was being proposed. The expression of interest we have would be for what I suppose would be a modern C2 use provided in a retirement-style village with close medical care and treatment, as opposed to being in a sort of giant institution. And that is within class C2. And I think the debate about hybrid isn't hybrid C2, C3. I think hybrid is the mixture of between what's called traditional C2 and modern C2. So that's set out there, sir, to paragraph 36, and identified.
Well, paragraph 37 seems to go back and is built on the foundation stone of that earlier point that you put, essentially that you suggest that GL Hearn are methodologically adrift.
Yes.
If we can forgive that rather untechnical term.
Yeah.
And the consequence of that adriftness is what you say.
That's right, sir.
In paragraphs 37 and 38 in your submission. And we then, and that, insofar as it goes, that's clear. Your position is clear to me.
Yeah.
Clearly the council's position may still differ, and I obviously need to hear them on the detail of that too. But you then go on to deal with delivery.
Yes.
And essentially then to critique. This builds on the oral submissions that we received when you personally were unable to be with us in that rescheduled session on the afternoon of the 12th.
Right, yes.
And it became clear to me at that point that we were aiming at different targets and moving in circles. So a kind of reduction of the concerns that were expressed.
Yes, there's a variety. There's a variety of quite specific concerns based not only on certainly as the council's position has somewhat somewhat shifted, and heavy reliance on delivery in the last 2 to 2 years, 3 years from 2013, which we critique as to why that's not a sound basis. There's the Hawkhurst Castle. There's a lot of quite specific issues to do with the number. Hawkhurst Castle, which in short is the council claimed, as I understand it, that they can take effectively a gross figure, because they say Hawkhurst Castle, its previous C2 use was abandoned. Firstly, we just think that's unsustainable, and we've referred to the officer's report when planning permission was granted. There was no suggestion at all, quite the contrary, that the previous use had been abandoned. And in fact, a bit of dereliction over 5 years. I'd be very surprised if this authority's development control people would be happy always to accept that would amount to abandonment. therefore we say that that's artificially inflating the gross figures. But even quite apart from the debate about whether it's officially abandoned or not, it's very difficult to say that if a site which had previously been used and recognised as a C2 use had not been used for C2 for 5 years, you can then gross it up and not look at it as a net provision, because we think that's unsound in any event. But we think it's unsound because it's simply, you can't say it's been abandoned. Then, and I've said we've already dealt with the, there are some other curious matters which the Council may want to explain in terms of whether there has just been wrong references. I think it's a TPO case, isn't it? Yeah. And applications relied upon which on their face don't seem to be relevant, one relating to completions related to YMCA building, and another that seems to be a TPO application, but there may be an explanation for that. So, I mean, that's I can go through it in detail, but that's just a sort of summary of some of the. They're all quite. They all add up.
They're all individual, and I guess this is a critique based on the contents of what then becomes statistics.
Yes. We say it's very important because the reason why normally one would think at this stage, well, we don't need to get too worked up about it. We do here, because the Council are putting all their eggs into this, we say, extraordinary basket. They're saying, okay, we know for a proper, if we're doing a plan review, we're never going to do this. This is a use that needs to be set out with a separate, this is what they say for the local plan review. But they're saying to you, sir, although we can meet this need for this plan allocation by just seeing how the market delivers and look at our track record, you can be confident because we've got such a good track record. Well, the first point is to say, well, any track record that relies on just 3 years delivery and not the wider thing, first of all, that's statistically suspect. And then second of all, one then looks at some of the figures that have been cobbled together. You rely upon grossing out Hawkhurst Castle with a novel argument about abandonment, which was never raised at all when the planning permission was granted. And then you look at various other matters of delivery that have been looked at, that we've cast doubt about, and we'll hear what the Council says about. And then you look at the more important issue that I said at the outset, that we're comparing apples and pears, that the Council on need, if we're right on that, is looking just at, through GL Hearn, traditional C2 need, but when it comes to doing delivery, it's looking at modern and traditional C2 uses. So if that's right, and again, or if you can't be sure that that's right, sir, then we would say, in order to make sure it's sound, there would need to be an allocation. So the reason we've looked at it in some detail is because the Council are asking you, sir, to do something that we would suggest is extraordinary and effectively not plan for meeting the C2 new and just allow the forces of the market to do it. So it's planning by not planning. And we don't accept in principle that's right. And for the reasons we've set out is that in any event, they would need to show some extraordinary amount of reliable delivery so that you can say, well, I know it's not really planning, but Tunbridge Wells just overwashed with C2 uses coming forward. And for the reasons we've shown, that's not the case. So on the sites located within the green belt, in a sense, sir, I haven't got much to add to what I orally addressed you, sir, when we were last here. And we just summarise, yes.
I view that essentially as a when I characterised the issues at the beginning of this morning's session, and I viewed that as being, in a sense, largely heard, and that's just drawing everything together and placing a hat on top of the character that's already there.
Yes.
I didn't have any additional questions that arose from that part of your written submission.
Well, I think I have dealt with it, but Mr. Buchanan rightly asked me to just briefly reiterate, because I think it is a new point, that we, as I said at the outset, if the council's submission now is that in order to be safeguarded land, you can't be considered for safeguarded land if you're in the green belt. If that's going to be seriously pursued, then we'll come back to it. But in our respectful submission, that's plainly wrong. That the whole point of safeguarded land is you consider land within the green belt, and if you safeguard it, you take it out of the green belt and you safeguard it. And the whole point is that land is available if a need comes forward to be used, without the need then to go back through the process of taking it out of the green belt.
Okay. Now, I'm conscious of the time. What I think I will do is I'll just ask CPRE if they have any particular observations to make. And if they do, and it appears that they do, I'm then proposing that we take a morning break, and then we hear from the council after that break. And I was then going to suggest that actually be slightly longer than normal, about 20 minutes, simply so it's not just a kind of rush off and cup of coffee break. It does actually provide the council with an opportunity to tick off on their list a number of matters that have been raised this morning. And again, they have had a paper in advance, but they have not had the paper that long, as indeed none of us have. So I think, a fairness, a little bit of extra time to enable them to collect their thoughts would be in order. So, CPRE.
I'm finding it difficult to accept this sudden new definition of modern C2 use. The council has for years been approving developments for the elderly where there were limits placed on the age group within which people could live in the flats or bungalows or houses provided. In fact, my mother-in-law lived in an orderly development in Tunbridge Wells. She was at liberty to eat either in the restaurant on site or to order in her own food. She was inundated with Domino's leaflets. She was at liberty to take her medical services from whichever local GP she chose. She was at liberty to take in, when she reached the stage of needing extra care, either from orderly or from the social services providers currently provided by Kent County Council. I can't see that setup, which is what I understand this modern C2 use is supposed to be, is really markedly different from the C3 that was just being described as very different. I mean, she was able to buy in services as she wished. That's rather a personal matter, so perhaps it's not something I should make for CPRE, but on the other hand, we are talking about what the planning definition of these things is. And as you said, Inspector, the planning definition doesn't seem to have changed yet. And it seems to me that this is not really the place for it to change. The place for it to change is through a statement of government policy guidance. As regards the green belt, I don't know whether we should go through the arguments again.
I would urge upon you not
to do.
I mean,
okay.
Let us bear in mind that, you know, we have had sessions where the express objective of the session has been to deal with those issues. They've also been very well articulated in writing on both sides, and I have a task, as I've said before, which is to absorb and inwardly digest the positions that have been put to me in writing. The purpose of this session was expressly to
deal with C2.
Deal with C2, and particularly to deal with what appeared to be unresolved and the sort of almost shooting at different targets position that we had reached when we attempted to deal with it rather extemporaneously and orally on Thursday, the 12th of November. And then, you know, the spaceships floating out there, you know, the greenbelt issue needs to be redocked with the other free-floating issue, which is all of the definitional stuff around C2. But I don't think we need to. That redocking happens in my mind. I don't think we need to re-argue matters that have already been well put and well argued.
Fair enough.
Okay. So in which case?
So I just come back to the fact that in principle, the housing for the elderly that is, as we would argue, the C3 type is not hugely different from the sort of housing that provides a gym and a swimming pool and a concierge, which is deemed to be perfectly normal C3 housing in many areas.
Okay. I mean, that's a clear submission. Deal with it on the basis of the law and policy as is. Thank you very much. Ladies and gentlemen, it is creeping up to 10 past, so let's call it 10 past 11. Can we resume at 11:30, unless the council is asking for any more time? 11:30 it is then, ladies and gentlemen. Welcome back, ladies and gentlemen. Everybody who was participating in the first half of this morning's session has returned, so I believe we can begin, and I will go directly to the Borough Council.
Thank you, sir. I don't believe I'm going to take too long to cover the points that the Council wishes to make in this particular session, given the weight of written and oral submissions you've already heard on this matter over various days sitting. Starting with the principle of the soundness of the plan, the Council's position remains, as previously stated, that we consider the plan as submitted is a sound document. The Council believes that application of a combination of the historic local plan policies, the core strategy, the site allocation plan and development management having regard to national policy can supply specialist housing for the elderly in the borough. Going forward, this situation will be considered, as you're aware, as part of the local plan review. The Council has been heavily criticised today and previously for its approach to development management and how it relies upon this, in the words of the representatives, in delivering C2 provision. However, as we've commented before, development management is an equal partner to plan making in spatial planning, and a proactive development management approach is indeed encouraged by government in its guidance and policy. Indeed, the Council's information, which is presented to you, demonstrates what the market has developed and will continue to develop in recent years going forward. And finally, on the development management approach, it is the case, pending any local plan review, that there is no reason why Cooper Estates cannot seek to bring forward their proposals by way of a planning application. However, they've chosen not to do that. Moving on to the nature and use of the promoted development, we've heard much debate, particularly today, about the different classes of housing to meet the needs of older people, and in particular reference to what is now seems to be termed traditional and new C2 use. What is clear to the Council is that the development being promoted through the submissions is for a particular form of specialist housing, and it would take the form of what might be called a retirement or care village with on-site care provision. What is being promoted, therefore, is not a traditional form of C2 use, i.e. an institutional care or nursing home, and indeed the development being promoted does not include such a provision. The physical form on the ground will differ from a traditional care nursing home situation, which would typically be a large single building divided into rooms or flats. And how the proposal differs from that traditional approach can be seen from the indicative site plan that has been submitted as part of provision statement. It follows, therefore, that the model of development being promoted is a proposal with occupancy based on a combined criteria of care need and occupational limitation, and that was confirmed by the submissions you heard this morning, sir. Moving on to the question of figures, it is the case that many figures have been exchanged and discussed. The Council has sought to agree the supply figures that it relies upon at each stage, but at each stage there has been a degree of disagreement with those representing Cooper's Estates. This has continued most recently in their submissions and oral submissions. The figures quoted in the provision supplementary November statement are not agreed by the Council, and in our opinion would require further adjustment if they were to reach agreement between the parties. Again, much has been said about what level of need exists, and you've had your attention drawn to various sources which might provide that information. The respondents refer to two sources of information read the level of need that might exist. The first is the SHMA, which was commissioned by the Council, and the second is the report prepared by Charterwood to support the planning application at Owlsnest Wood. In terms of the SHMA forms part of the evidence base for the local plan review, and as such is untested and does not take account of planning constraints. As far as it may be relevant to this examination, it is clear that it seeks to identify an overall level of housing need for the borough, including specialist housing for the elderly, which may take a variety of forms, including sheltered housing and both traditional, institutional and modern C2 uses. The Council has revisited its figures regarding completions, having regard to the latest criticisms made to those figures, and the Council believes that this shows that for the 3-year period of 2013 to 2016, the outcome across the range of specialist housing would be 395 units, compared with a combined SHMA target of 330 units.
Can I just pause you there, because these are coming in orally, and I just want to make sure I've got those figures correctly. So can you just run me through that
Yes,
again?
for the 3-year period 2013 to 2016,
Yes.
we believe the outcome figures across the range of specialist housing which would include both traditional and modern C2 and other specialist housing, so the combined specialist housing, would be 395 units, which compares with a combined SMAR target of 330, which is 3 times 110. And the 110 is made up of 70 and 40, as referred to in the SMAR document. In its original submission statement, Provision on behalf of Cooper's Estate quote directly from the SMAR report to support its position. However, it is significant that in later submissions, criticisms of the SMAR have been introduced and increased. However, the Council thinks it's important to note that no criticism to date has been made to the 110 units, which is the combined 70 and 40, which is set out in the SMAR, and which seeks to identify the level of need on an annual basis for elderly people specialist housing. In terms of 2 detailed points made by representatives on behalf of Cooper's Estate, Para 2.24 of the November Provision submission makes reference to the SMAR in the context of the Highgate Hill appeal findings. It should be remembered that those findings were relevant to a Section 78 appeal situation, which is not the same context to the current DPD examination, and that was a point that was made when we were discussing the general housing. It has been accepted that it's not the purpose of this examination to reassess the level of need set by the core strategy. A second detailed point relates to paragraph 14 of the closing submissions, which you have a copy in writing. And the Council believes that paragraph 14 of the closing submissions misquotes the SMAR report when talking about paragraph 7.33. And we would only ask, sir, that you look at the SMAR and that paragraph and you review it yourself in full context. The second source of evidence of need, which is relied upon on behalf of Cooper's Estate, as I said earlier, is the Carterwood report, which has been prepared in the context of a planning application for another site. And it should be noted, therefore, that Cooper Estates rely on the SMAR to a certain degree and that report. They have not commissioned their own needs assessments and presented it to this examination. Given the reliance on the Carterwood report, the Council would draw your attention to certain elements of that report in order that you can consider them in deciding what weight you give to that report in your considerations. And there's just 4 bullet points on this. First of all is that report is providing evidence to support a planning application and includes an assessment both of traditional care home and extra care units. That scheme includes both those elements, whereas the scheme promoted by Cooper's Estate does not. Second bullet point is that in that report and in identifying planned supply for the period 2012 to 2015, the evidence in that report falls short of that identified by the Council. And indeed, the consultants who prepared that supporting report to the planning application at paragraph 2.5 of their report confirmed that they are not certain of all the supply in their assessment. The Council would argue that they have not included all the supply in that assessment. In a similar vein, paragraph 26.6 of the report confirms the shortfall of the approach that they have taken to trying to identify demand. And again, I would emphasise that they use the word demand there rather than need, and there is a difference between the two. And finally, regarding that report, I would draw your attention to the fact, if it may be relevant to consider the more traditional care home need, Table 9 and Table 15 of that report, you can see that the total care home bed provision in the borough is greater than the estimated demand. Thank you, sir.
Thank you very much. Now, I'm just rechecking my notes. To see if there's anything else that I need to address with you. Can I just ask you to turn up page 8 of the Cooper Estates written note of proposed oral submissions that we received yesterday? And there, from paragraph 39 and then over the page through to 41, there is a specific critique of delivery. I just wanted to be clear of your response to those two particular paragraphs, 40 and 41.
Thank you, sir. The first point I think I would make is that even if we would accept that even if you were to adjust the figures, for argument's sake, in line with the criticisms that are made, the council would accept that the trajectory of delivery over the period has increased to its most significant in the last couple of years. And in our submissions, we haven't denied that. The difference between the council and Cooper Estates is the significance of that and the weight that you should be given to it as a indication of what might happen in the future. The council says that that is a strong indication of how the market has responded to the need, and also in the context of the planned situation which exists. So whatever criticisms may be levelled at the local plan, the core strategy, or indeed the draft plan, that has not frustrated the market in presenting planning applications and receiving permission, and then actually delivering those permissions on the ground. And so that reinforces the point I made about the role of development management in the overall planning situation.
Okay. I was also wanting to ask specifically about Hawkhurst Castle. And just to be clear, because there are two possible interpretations in terms of, I guess, the accrual of the number of units related to that particular development. One is that the preceding development was a use that became abandoned, and therefore at the point relevant to your figures, the inclusion of that site in your figures, it had no lawful use, in which case you accrue the gross number of new units, or alternatively it did have an existing lawful use, in which case growth is a net figure. And I just wanted to be completely clear that it's either your submission to me that there was a former C2 use that had been abandoned, or alternatively that there wasn't.
In terms of the impact on the figures, I think that those scenarios are set out in the statement of common ground.
Yeah.
Notwithstanding the footnotes that were added on behalf of Cooper Estates to make clear where the disagreement lie. The council's position on that particular site has been that the length of absence physically on the ground and the use existing for a considerable number of years was such that the total figure of net increased units for that particular site should be taken at a base point of 0, not the 54 that existed at the last time it was in active use.
I mean, clearly I will return to the statement of common ground, and if it turns out that I have any further questions on that, then obviously those can be addressed in writing. Now, apologies here for leaping around a little bit, but this was the order in which I wrote the questions down, so I'm afraid this is the order that we're running on. If I can just ask you to turn back to page 8 of Cooper Estates. Submission received yesterday again. And in the light of paragraphs 37 and 38 there, under the heading Identified Need, this was the point at which I sought to confirm with Cooper Estates whether it was their view that the GL Hearn work, SMAR, was, to use that wonderful catch-all phrase, methodologically adrift. And they explained to me that they believed that it was, and they explained to me their view that those two paragraphs captured the consequences of it being adrift. Now, you've now heard fully what they've said at some length, and I just wanted to go back and check with you your position, methodologically adrift or not.
So the first point to make is that the council's position is quite clear, is that the GL Hearn SMAR report in its totality deals with all aspects of need of housing for the elderly. It breaks those totals down into what has been referred to as a traditional, if you like, C3 and C2 category. And we've had a big debate about whether things have moved on from that, but that's how that piece of work sets it out. And therefore, any element of extra care, modern C2, as it's been referred to, is part of the 70 per annum need figure. The other element, as we've heard, is the traditional C2 element, which amounts to 40 units per annum. And if you add the 70 and the 40 together, you get the 110, which I referred to earlier, and which hasn't been challenged by Cooper's estate. So those two figures together make up the total need across the board. Yes, the C2 modern element is not identified in its own right as part of the 70, but it is part of the 70.
Thank you very much. And again, I'm just making clear, so I'm not going to pass back over site specifics or greenbelt matters for exactly the same reasons as I indicated earlier in opening with Cooper Estates, that it was a matter that we had already discussed at some length, and there have been copious written submissions, and we were essentially there, largely heard in any case. So that brings me...
Just to confirm, sir, that we're content that we don't need to say anything further on those matters.
Okay, thank you very much. Now, we've had quite long and quite complex oral submissions. So what I am going to do is I'm going to accord, in this order, first CPRE, then Cooper Estates, a brief opportunity to draw together and make any final concluding remarks that you feel you need to before I close the session, and then I'll provide a final word to the Council if it's necessary to do so. So, CPRE, is there anything further that needs to be said on your part?
No, Inspector, I don't think so.
Thank you very much. Cooper Estates.
Thank you, sir. Could I just deal briefly with focusing first on some of the answers that you were given to your questions and then briefly responding orally. First, could I deal with the point you put to Mr. Hinton about the reliance now of the Council on completion rates? Now, Mr. Hinton says they're relying on the last 3 years. We say that's not an appropriate methodology. But in any event, it goes a bit further than that. Could I ask you, sir, just for your note, if you have it, the Council's document PS/36, which is ID 14, Action 1, Position Statement C2, Land Supply. And it's the Table 3 that has these figures set out. Page 7.
It's 36, ID 14. Yep.
Yes, sir. Table 3, which is I'll say under paragraph 22 rather than a page number, because the page numbers may be different on the electronic version. I don't know. Don't know. Net completions for C2 for 3-year period, 2013 to 2016.
Yes, I
So
have.
you've got our submissions on 3 years and also the inappropriateness of going all the way to 16. But if we actually look at the years, we've got 2014 13, all traditional C2, 2015 minus 5, and then it's 1 year that the whole case turns on for the council. 2015 to 17, 230. Yeah, 230, which is actually 97% in 1 year. So you're being asked, as far as I understand, quite apart from all the other criticisms we have, is that this is said to be a sound methodology of an uncompleted year, of a windfall of 234, and to base that, sir, because it's 1 year, because I can't imagine the council are relying on minus 5 and 13 as a supply. But even then, what you see of that 3 years, if you were to look, and we don't accept that 3 years is an appropriately long period to judge, but of that 3 years, you see 13 minus 5, 2, 3, 4, and the council say, oh, you just roughly average it out, and you'll find that that's satisfactory. Well, one only has to pause for one moment to see that is a thoroughly unsound methodology. Could I then turn to Sir G.L. Hearn and the answers that you were given by Mr. Hinton there? It's clear, sir, from the answers that our criticism is well-founded. G.L. Hearn has not separately assessed in the SMAR all aspects of C2. We've called it traditional and modern C2, but this is not something that's just been made up or new. This is everywhere else, apart from apparently Tunbridge Wells recognises this type of use as C2. And we'll come back to see that Tunbridge Wells, in fact, recognises so-called modern C2 as C2 because they've included it in their completion rates before you, sir. But if we have a look at what G.L. Hearn's done, is there is, as set out in our oral written statement, the critique, it is clear that the 70 does not include modern non-institutional C2 uses. For the reasons we've set out, we don't explain. All we have is Mr. Hinton asserting that it does. And I'm afraid we have to take issue. Mr. Hinton says that we don't challenge the 70 plus 40. Yes, we do, because it's my apples and pears point. The approach the council take is to look at delivery based on a modern and traditional C2, but to look at need only on a traditional C2 basis. And that is the evidence. Now, insofar as traditional and non-traditional C2 use, I listened with care to what Mr. Hinton said about the orderly home presentation. He said it wasn't an institutional, not an institutional C2 use. Traditional, and he spoke about the description of the retirement village. I noted that he did not assert that it was not a C2 use. And he's right not to do so. And that's consistent with the council, as I said, approach on completions that have included similar types of so-called modern C2 as their completions. And so you see that elaborated, just for your notes, sir, in annexes PV1 and PV2 of the Cooper Estates main issue 3, November 2015 documentation that's in answer to your questions, response to ID 12B questions. The fact is that the only, sticking on this theme, the only proper analysis that has been done between the C2 uses is that found in the Carter-Wood work. And I just want to deal briefly with the four points that Mr. Hinton, I think it's the first time that Council's made those points, but it matters not. With due respect, they're all unsound, in criticism of that work. And I just want to make sure. The first point is it's said that that work was commissioned as part of a nearby planning application that had a mixture of traditional and modern C2 use. Well, the short answer is, with all due respect, so what? That doesn't affect the validity of its calculation of need. Another point is said against it is that it doesn't distinguish need and demand, but Mr. Hinton didn't elaborate as to to what extent there was a distinction, if at all, and if one looks at the Carter-Wood report, it is entitled, and certainly understood itself to be, a needs assessment. That's in the title on the first page, which is at PV1 of our October 2015 representations. And at 1.3, it sets out the instruction was to carry out a needs assessment based on a market catchment area for the care home and extra care elements, as well as the Tunbridge Wells borough area. And a point was said that the report had suggested that it might not cover all the potential supply. Whether that's right or wrong, the Council haven't identified any particular supply that wasn't taken into account, which the Council say is relevant. Just then, turning to the question of the Council's own work, we do not understand there to be a response to the points I made orally, and which we'd already flagged up for your notes, sir. It's provision. It's the November 2015 document, which was the response to your ID/12B questions. And at paragraph 2.2, we have indicated at PV1 two planning applications relied on by the Council as a source of C2 development land supply completions. We say do not relate to C2 use, and we set them out. It's the YMCA, which I referred to, and it was also what I also referred to as the details of a tree protection order. Now, those are relied upon for 9 and 24 units, respectively. And they've been flagged up as miscalculations, and we must assume, therefore, that the council, and I flagged them up again, doesn't take issue with that and accept that those are matters that should be removed. I won't go through the other points of criticism to which we respectfully say we haven't had a meaningful response to from the council. We just pause to note we do not. Mr. Hinton referred to a figure of 395 as delivered. We are struggling to find that particular figure set out in the council's documentation. And it's certainly not in PS 36, the position statement on land supply. The other point that was made against us, apparently, and I would say rather unconventionally, we were told that we should rather be promoting the site as a planning application. That's the first time I've actually ever come across a situation where a local planning authority, in response to clients promoting through the plan process a site, have told that we shouldn't really be here. I presume that's the implication. We should be pursuing a planning application. But with all due respect to Mr. Hinton, and that I think probably is the consequence of this council's approach to this issue, that it's not for you, sir. It's going to be dealt with by so-called development management, which will be planning by appeal. That is the complete antithesis, not only of the MPPF, but of the statutory scheme. The statutory scheme is a plan-led scheme, Section 38(6), Section 70. And it is revealing, but not surprising, that we are told we should go off and apply for a planning application, to which we will be told, no doubt, that we're not an allocated site, we're contrary to the development plan, and to go away. Or are we going to be told, yes, thank you very much, as long as it's all okay, you can have planning permission, in which case I'd be surprised. But it brings me on to my final point, sir, is there's been no response from the council to the point that I made in opening about having your cake and eating it. That the council suggests that by simply allocating for conventional housing and identifying, I think, 2 sites that might be suitable, and there's a bit of confusion in wording as to institutional or just elderly care, C2, C3 use, but that matters not for this purpose. That is good enough. And I highlighted the implications that could have for affordable housing. But no answer to that from the council. And of course it goes further, because if we are in the planning by appeal world, that planning by application rather than by planning, Mr. Hinton suggests, what then happens if we come forward on a site allocated for housing that may be suitable, they say, for C2, and we offer no affordable housing? Would the council be entitled to refuse planning permission? On the face of it, it would. The plan is allocated for housing. There's a requirement for affordable housing. It may be suitable for C2, but then you look at it and you see, well, it's not an allocated site, and it's going to take away much needed affordable housing. If, however, the local authorities say no, that would be in accordance with the plan, then the council would have to readjust its affordable housing and conventional housing figures, because it can't come to you and say, sir, we're going to deliver, this plan will deliver that level of affordable housing and conventional housing. That can't be sound. So we do say, finally, that the only alternative, given that, and it is not, cannot be refuted, that as the paragraph 17 of the MPPF says, it's the primary main core planning purpose, it's genuinely plan-led. First. Second, that there's no dispute that the core strategy identifies a need for C2 housing, not disputed. 3, it's not disputed that this allocation should seek to meet that need. And 4, for the reasons we've set out before, simply suggesting that sites allocated conventional housing could meet that need is not sound planning. We do say the only option is to allocate, although we do say, for the reason we set out, it could be reserved land. Yes. Mr. Buchanan finally, and this is finally, reminds me of the policy support for something I knew would be instinctively right. It's unusual to find it reflected in government policy, one might think. But anyway, there we are. 154, the MPPF, local plans should set out the opportunities for development with clear policies on what will or will not be permitted and where. Only policies that provide clear indication of how a decision maker should react to a development proposal should be included in the plan. And we say that, quite apart from everything else, the two areas where C2 is said to be suitable are housing allocations, and of course 157, the fifth bullet point of the MPPF, makes it clear that crucially local plans should allocate sites to promote development and flexible use of land. So if there is a need, we do say that it should be met by allocation. And we have a site which we've reduced in size before this inquiry, not on the basis of reduced need, because the new need is there, but that will be oven ready and pretty much ready to go. Unless I can assist further, so those are our response submissions.
Thank you very much. No, those are clear, and I had no questions upon them, so I will just return to the Council and provide them with an opportunity for a final set of concluding remarks.
Thank you, sir. Just responding to two matters that you've just been addressed on. The first was in relation to the comments that I made about the Carter Wood report and the fact that it doesn't take account of all sites and permissions. And on that point, sir, you just need to compare the tables in the Carter Wood report to the Council's own tables of supply, and you will see that the Council's list of supply is greater than the Carter Wood report. So you have that all information before you, and you can reach your own conclusions. The second point again relates to the Carter Wood report. It may well be that the title on the document says one thing, but I would refer you to page 34 and section 26, which is headed Morphology to determine shortfall of extra care, and straight away the first subheading is demand. It's not need. And again, I've already referred you to paragraphs 26.5 and 26.6, where the word demand is used. Thank you, sir.
Thank you very much. Ladies and gentlemen, I believe we have brought oral submissions on that matter to a close. That was the only matter that was programmed to be heard in this morning's session. So, as I previously indicated, I am now bringing that session to a close also. We will return at the advertised time of 2 p.m, but that will not be in hearing mode. That will be in business session to programme the homework, for want of a better description. Any person who has been interested in the hearings is, of course, at liberty to attend that session. It's open and public in the normal way.
So, could I just say thank you very much? Can I say I'm sure on behalf of all the advocates who, for the non-local planning authority parties that have attended, for the hospitality of the local authority, the programme officer, the officers of the local planning authority, and to you, sir, for the assistance that you've provided to us. It's always a bit difficult when one's coming in and out for things to be fitted in. And could I thank the local planning authority again, and you, sir, and the team for certainly from our experience, and I'm sure I speak for the others as well, for facilitating that. And lastly, could I just ask, without being prescriptive, if there is anything that obviously might concern Cooper Estates in the afternoon session, because if there isn't, and I hope it won't mean as a discourtesy, that we may not be here in the afternoon. For that reason, I've just indicated my thanks on our behalf, and I'm sure on behalf of the others who have appeared here.
Well, thank you very much for those kind words. Essentially, the council are the main focus of this afternoon's conversations, and as I said, anybody else is at liberty to be here, but there's no particular necessity or requirement, because whatever arrangements are agreed and settled will be confirmed in correspondence, and there will be dates. So, the only reason for anybody to attend might be to say that they have particular issues with particular dates or any such matter, but other than that, that's how things will be dealt with, and they will be communicated.
Thank you very much, sir.
In which case, ladies and gentlemen, let us now formally close this hearing, and we will return at 2 p.m. for the business session.